Okay, the next item on the agenda that we're going to address will be Resolution 2014-0161. Will the clerk please read this item?
Resolution number 2014-0161, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 5, Section 5.01, Appointment and Confirmation of Officers, and Section 5.08, Sheriff, Powers, Duties, and Qualifications, establishing the term of appointment and process for removal of the sheriff, and declaring the necessity that this resolution become immediately effective.
Okay, very good. Is there any public comment on this item?
Yes, there is. Mr. Akers has requested, and Homer Taft.
Okay, very good. Mayor, once again, 90 seconds.
Oh, I'm well aware of that, sir.
Thank you.
Mr. Chairman, members of council, we strongly urge the support of this amendment. We realize that now that the sheriff is no longer elected, we feel it's important, though, that that office, the main independence of that office be maintained. Therefore, that's why we urge the creation of the staggered terms. We also feel it's important if, for whatever reasons, the county executive wishes to remove the sheriff, that they be a supermajority of the members of council confirming that rather than a simple majority. We think that in light of the need for that independence, that this resolution is in order. We urge your support for that.
Very good. Thank you. Mr. Taft.
Thank you, Chairman Greenspan, President Connolly, members of council. I'll be very brief on this one. I'm Homer Taft of Bay Village. I had appeared before the Charter Review Commission, particularly in support of this, so I wanted to speak my support to it. I initially thought I was going to talk to you at the beginning because I had a few times, so you'll put up with me a couple more times, but I'll get them in short licks. Thank you.
Very good. Thank you. Any other public comment? No. There are two amendments, two proposed substitutes. The first one we'll hear will be from Councilmember Simon.
Thank you, Mr. Chair. Amendment speaks to council's confirmation of the removal of the sheriff as it's currently situated. It states that there needs to be a supermajority of council to confirm removal of sheriff, and I think that's too high of a bar to overcome. So my amendment simply just changes that supermajority to 6 members of council. And if we're going to do this, and this, I'm not comfortable with this provision to begin with, but if we're going to do it, I think council should not have to reach that high of a bar.
Okay, very good. And I'll hold off on my amendment until we have a vote on this. So, any further? This one needs to be introduced. So, Ms. Simon has a proposed substitute, Resolution 2014-0161. I assume you have a motion.
Yeah.
Very good.
To change the supermajority to simple majority of council to 6.
Is there a second? Mr. Hairston was the second. Okay, we can further continue discussion. Is there any further discussion?
Yeah, what's the difference between just saying a majority of council or specifying the number 6?
Maybe
what if we were short a member or something? So, would it be better to say, calling our lawyers, would it be better to say a majority or?
I think fundamentally it would still require 6 votes of council to qualify as an act of council.
Okay.
So it's sort of 6 of one,
Okay.
half a dozen of another.
The reason, I assume that the reason that the drafter put in 8, that it would actually, it lifts the requirement to a higher bar to say that you don't do this lightly. So I see what Ms. Simon is saying, but I'm kind of betwixt and between. I kind of like the idea of having that additional 2 votes so that this is just not done lightly, because removal of a sheriff is a very, very serious matter. So I'm kind of betwixt and between on this one.
Mr. Brady.
I come from, have evolved to some extent on this issue over the last 3.5 years. First, I was for retaining an elected sheriff. Then I've warmed up to the idea of appointing a sheriff. And then I thought that the sheriff should be appointed for a set term and not be able to be removed by the executive at all, that they would be removed like anyone else would be by those folks who have the authority to do that. And but I'm not, since I'm not proposing that specific amendment, this will sound contradictory, but I don't like the executive or the council being involved in whether the sheriff is fired or not. I don't like either one of those options. I will be voting for Councilwoman Simon's amendment, however, because I think that if we're going to continue to allow the executive to remove the sheriff from office, that creating a supermajority seems to indicate that would be more likely to create friction between the executive and the council over the issue. I think if a majority of members of council think that a sheriff should be removed, that's probably a pretty high standard, because I can't see myself under any, except for extraordinary circumstances, ever voting to remove a sheriff.
Okay, very good. Mr. Germano.
Thank you, Mr. Chairman. Well, I'm firm in thinking that it should be 8. I'm firm in the proposition that the sheriff should be a professional law enforcement officer, not a politician, so he shouldn't be elected. And I think, the council has got the responsibility to check the appointment, whoever is appointed, to check to see if he's qualified. And once we go through that serious process, there should be some independence on that sheriff the sheriff or police department is a paramilitary organization. And, when you get civilians involved in paramilitary, if you want to just use the analogy, I think there should be, the sheriff should know that he has been chosen because of his credentials and experience, and he's going to have some independence. So I'm all in favor of voting no on the 6 and keeping the 8.
Okay, any further discussion? Mr. Schron.
And I'm in agreement with Mr. Germano, because I think it does build that independence by saying that it's a high threshold in order to let this person go. It doesn't mean it should be an insurmountable threshold, but it should be a high threshold because who knows where that investigative authority might go. We know that we're going to be sitting in an executive session listening to this, which will not be subject to the public hearing about this personnel matter, actually, and then we'll come out into public session and make a vote. I think that when they hear a vote that comes into supermajority, it will be pretty clear that this council has also supported the county executive in that determination to eliminate that position.
Okay, just to provide a summary, the variance between the original submission of this item and Ms. Simon's proposal is merely the delineation between the number of members. Both are 4-year terms, and the original proposal was 8 members. This proposal is 6. As the author of the original resolution, I support 8 for the same reasons that Madam President supports 8, and would prefer to keep it at 8 years. I'm sorry, at 8 members. If there's no further discussion, we have a motion, a second. We'll do a roll call vote. Madam Clerk, will you please call the roll? This would be for Resolution 2014-0161, Ms. Simon's proposed substitute.
Ms. Conwell?
Yes.
Mr. Jones?
Yes.
Mr. Hairston?
Yes.
Ms. Simon? Yes. Ms. Conley?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
No.
Gallagher?
Yes.
Mr. Strawn?
No.
Mr. Greenspan? No. Motion carries.
Okay, so the resolution before us now is Ms. Simon's resolution, which shall set the term at 4 years and the removal at 6 members. I've a separate proposed substitute. The fundamental difference between this one actually is a moot point. It changes, number one, the term to 6 years, but requires 8 members of council. Based on the last vote, I'll withdraw my resolution. So the resolution before us then is Ms. Simon's resolution, substitute resolution. If there's no further, yes,
Your proposed substitute actually does a few other things, so I just wanted to make sure you were.
okay. Well, Mr. King, would you please?
Sure. The proposed substitute, this actually came on the recommendation partially from the law department. First, it would change the term from 4 years to 6 years, but also additionally, in section 1 under 5.08, it would add the language, the sheriff shall also have such powers, following the section that says that all powers and duties now or hereafter vested or imposed upon county sheriffs by general law shall be carried out by the appointed sheriff. It says the sheriff shall also have such powers and duties as shall be established by ordinance that are not inconsistent with general law, and that the sheriff shall serve at the direction of the county executive. And this was sent over by our law department basically to clarify that the removal provision was not an intention on the part of council, and I believe this was part of the discussion at the past committees, that the sheriff's office was not to become an independent office, but would simply, for the sake of investigations, add that removal threshold, so that the sheriff would still serve at the direction, if not at the pleasure, of the county executive.
Okay, and that was the other item that this ordinance, other than the 6 years and the 8 members.
Correct.
Okay, all right.
Mr. Chair, where's that language? Now I'm looking at the substitute,
Page
right here,
21.
section 5.
It's at the
Page
top of
21.
page 21.
Yeah, section 5.08.
Right. I did withdraw, but I'll if I can reintroduce. Okay. Madam President?
Yeah, I have a real problem with this wording that the sheriff shall serve at the direction of the county executive. The sheriff is historically a very, very important agent. I mean, in medieval times, the sheriff, remember the sheriff of Nottingham? But no, the sheriff is a very, very important, he's a chief law enforcement officer. He or she is a chief law enforcement officer for the county. I think there's this great bit of trivia, the only person that can arrest the coroner is the sheriff. I think that it's important that we have an independent sheriff that makes a decision as to what kind of investigation he or she makes. And we've gone to all this talk about the independence of the inspector general. So I really strongly object to any wording that says the sheriff shall serve at the direction of the county executive. The sheriff looks at a situation, this is a trained law enforcement person. He or she makes a decision as to whether or not to carry out that investigation. And then we're gonna have the county executive, who may not be a lawyer, just say, well, I want you to investigate such and such a thing. I don't think this is appropriate at all.
Okay. Any further discussion? No further discussion, then I will now withdraw this. And we'll move on and vote on Ms. Simon's. Yep, Mr. Miller.
Do we still have an amendment?
No.
We're discussing the main motion, is that right?
Ms. Simon's substitute has been adopted and is a legislation to be voted by this body. Any further discussion?
Clarification, Mr. Chair, since we're now voting on Councilwoman Simons, which just, from the original legislation, is just changing the members. the members on removal.
Yes.
Mr. Chair.
Mr. Chairman.
None of the other stuff that you've.
Correct. Yeah, Mr. Miller.
Mr. Chair?
I'm sorry, we'll go to the law department, then Mr. Miller.
Okay. From the perspective of the law department, Mr. Greenspan, the amendment you proposed, there's also the amendment to section 5.08 also clarifies the sheriff's duty under the county's home rule powers with the wording, the sheriff shall also have such powers and duties as shall be established by ordinance that are not inconsistent with those provided by general law. In discussions with Law Director McCloof, and I believe that reflects prior discussions on this particular issue, that language is critical to clarify the county's home rule authority with respect to the office of the sheriff and to clarify his powers and duties as we've organized our form of government.
Thank you for that. Mr. Miller.
Mr. Chairman, the discussion particularly over your substitute helps illuminate some of the serious concerns I have about this proposal. I think it creates a new silo. It's something that we were trying to get away from. It will make it harder to have an efficient and coordinated county-wide policy on things like pay equity and IT and fleet management. When Council President Conley expressed concern about the language saying that the sheriff will operate at the direction of the county executive. That suggests to me that if we don't have that language in there, it means that the county sheriff is not going to operate at the direction of the county executive and is going to be running a separate system, which is what we were trying to get away from in county reform. It creates a fuzzy line of authority where we don't know the extent to which the sheriff is under the direction of the executive or not. I also share the assistant law director's opinion that not having the language in there about that the sheriff may also perform duties assigned to it by ordinance that are not inconsistent with general law, that it weakens our home rule authority to have the sheriff perform under the direction of the executive and the council. And I just want to say also that what we're doing now is not broken, and there's no need to fix anything right now. I think we have a new county government that's working, and the issues raised by Councilman Greenspan's substitute with a different term and the question about the degree of direction by the executive and the question about performing duties as directed by ordinance. There's just still a lot of moving parts that are not resolved, and I just don't see any reason why we need to put this on the ballot this year. And so I'm not going to vote for it, and I would encourage my colleagues to do the same.
Mr. Gallagher.
I agree wholeheartedly with Mr. Miller. This was born out of what I think is a knee-jerk reaction to the removal of the first sheriff, which I think we all can agree wasn't handled in the best of ways, with many of us still in the dark about why. But I don't think it's a situation where we have something that's broken. I think if we're going to do something like this, we need to discuss it further and get more in depth, and also
Why would we treat a previous elected official such as the sheriff any different than the clerk of courts, the treasurer, the auditor, the recorder? If we're going to do one, we should do them all. And in this, it just seems that we're bunching we're focusing on the sheriff, and I don't think we should.
Mr. King.
Yeah, I'd just like to, thank you, Mr. Chair. I'd like just like to clarify that one sentence that, that the Assistant Law Director referenced: the sheriff shall also have such powers and duties as shall be established by ordinance that are not inconsistent with those provided by general law. That is language that is included in nearly all other Article 5 officers. It applies to the medical examiner, the clerk of courts, the director of public works, the county treasurer, but it was omitted from the section governing the sheriff. I believe this was an oversight, and I believe that's why the law director recommended the inclusion of that language in this charter amendment as basically a bit of cleanup related to that section.
And what I will then propose is that with the exception of the last sentence in my proposed resolution, 5.08 subparagraph 1, that language be inserted, which would include that sentence. I understand the purpose for it. So I will make a motion to amend the proposal, actually the resolution that's before us, to include the powers and duties as follows. Powers and duties now or hereafter vested in or imposed upon county sheriffs by general law shall be carried out by the appointed sheriff, which is currently written, the new language. The sheriff shall also have such powers and duties as shall be established by ordinance that are not inconsistent with those provided by general law. That's my amendment. Is there a second?
Second.
Motion's made and seconded. Any discussion on the amendment? Mr. Sharon.
I have a comment.
Ms. Simon.
And I do too, whenever.
If we're going to include the powers and duties, I'm not sure why we're not incorporating what the charter gives to the executive, which is the direction over the sheriff. And I think if you are going to include this language, it has to be, doesn't have to be, but it should be consistent with the charter, so there's no ambiguity about what the intent is of this legislation. The charter currently gives, the sheriff does serve at the direction of the county executive, and nobody disputes that, as the charter states. So why wouldn't we make sure that this is clear? And I think that goes to Mr. Miller's point, that if we don't include that somehow there's some ambiguity about to whom the sheriff reports. And it's certainly not council. As the charter currently reads, it's to the executive. So if we're going to make an amendment to be consistent with the charter, we need to be consistent with the charter and not leave that out, because by omission, that might create ambiguity and question.
Mr. Chair?
Yes.
From the perspective of the law department, that last sentence could be a policy choice if the council so chooses. There are other officers in the charter. The law director would be the prime example, who do not, that language isn't in 5.06, because the idea is that as counsel to the executive, the law director should be independent. So that could be a policy decision, whether to include that last sentence and allow the sheriff to be, or create that sentence that creates the accountability to the executive.
A question to the law director. What is the charter-specific language as it relates to whom the sheriff reports, or serves at whose direction?
For the law director or for the sheriff?
No, for the sheriff.
For the sheriff.
As I recall, the sheriff's in Article 5. The sheriff
Right.
serves at the pleasure of the executive, not at the direction of the executive.
As it currently stands right now, at the start of Article 5, all Article 5 officers serve at the pleasure of the county executive.
Correct, not at the direction, and the interpretation of the direction of the county executive could imply an interference in investigation if the charter specifically states that the sheriff is at the direction of the executive.
Stand corrected.
All right, thank you.
Mr. Chair?
I wasn't intended to, I just wanted clarification on that point.
Mr. Chair?
Madam President.
I've always felt very strongly that the sheriff should have a term of office. And, this amendment would provide for that. I don't agree with Mr. Miller thinking that, we're going to create some special fiefdom. But I do also agree with Mr. Gallagher. This is, you know, I've said all the time, you don't amend your charter, your constitution willy-nilly. This is, you know, it's a very, very important decision. So I'd be willing to go along with Mr. Gallagher and make sure, let's wait on this one, because we want to make sure we get it right. Because this would be very, very important. And we want to make sure that we're in compliance with the state law, because the state law sets up duties for the sheriff. And I just think there's something, we could have unintended consequences.
Okay, before, yeah, Mr. Braid, just to be clear, right now, there's been a motion and a second on the amendment, on the amendment of the language of the powers and duties.
Okay, well
is-
then I'll hold.
Okay,
Fine.
is there any discussion on that item, and then we'll bring it to a vote, and then we can move on to other,
Where are you putting this amendment?
in,
That has already been amended? Yes. Okay, and, well, we're calling it mine, but the one that
your amendment is the moving legislation.
okay.
Legislation to be added to section 5.08, paragraph 1. Right now, it's on top of page 21, and it's going,
It's going on page 24, correct? That the language we're inserting is on page 21.
with the exception of the last sentence.
And can you read for the record which ones?
Sure, so the insertion would be in 5.08, paragraph 1, powers and duties, the new language, the amended language continues on after sheriff period. The sheriff shall also have such powers and duties as shall be established by ordinance that are not inconsistent with those provided by general law, period. That's the amendment that's been made and seconded. So if we're looking at it on page 21, first paragraph, second sentence is being copied and inserted on page 24 at the end of section 5.08, paragraph 1.
And you're deleting the final sentence? Yes. Okay.
Okay. Any further discussion on the amendment? Okay, hearing none, we'll do a roll. Oh, Mr. Boyle, 15.
Just in brief, to follow up on what President Connolly said, the statutory provisions for the county sheriff's office are quite large and extensive, and I believe that of the charter positions under Chapter 5, those that were previously elected offices, I believe that this was the most recently amended by the Ohio legislature to adopt very specific performances. So, because when we went through the nomination for current Sheriff Bova, the packet of paperwork, and Gene can attest, is quite large, because there's a lot to make sure that they have peace officer training, et cetera. It's a much different threshold for holding that office than it is for any of our other offices. So I don't know what the drafters of the charter it did or did not include, but I don't believe, just in a flippant manner, that this language was was nonchalantly excluded. I do think that there was a discussion, I would assume that there was, about the sheriff's office because of the very specific and extensive qualifications for holding that office. This followed on, obviously, some situations that those of us who have been around for a while realize that you can't, they grandfathered in previous sheriffs, but that to make sure that the people that held that very important office had the skills, the qualifications, and the background to hold that office and weren't just political animals.
Okay, very good. Very good, okay. Any further discussion? Clerk will roll call vote on, this is on the amendment to add the sentence as written.
Calling the roll, Ms. Conwell? Mr. Jones?
No.
Mr. Hairston?
Yes.
Ms. Simon?
Yes.
Ms. Conley?
No.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Mr. Greenspan? Yes. Motion carries.
Very good, thank you. So now the resolution before us is Ms. Simon's resolution on page 23, with on the top of page 24, under powers and duties, that additional language has been added. Is there any further discussion?
Yes, Mr. Chairman.
Yeah, Mr. Brady.
I'm going to vote yes to move this forward, but I'm not committed to voting the next time this is in front of us. I'm not committing to put it to putting this on the ballot. There's a variety of reasons. I think that this is an important discussion. I do think that sheriffs traditionally and currently hold very important positions historically in county government. Ours is actually a very unique exception to that, and of course, you know, while I'm okay with appointing a sheriff, I'm still interested, as others are, in that sheriff having a certain amount of independence. I hear what Mr. Miller says. I'd like to hear some more of that because I'm not quite sure a lot of what the councilman was talking about isn't also in the purview of the council and not just in the purview of the executive in terms of discussions about fleets and you know, other issues that in regard to the sheriff's office. So I'm going to vote yes for this. I'm not just saying ahead of time. This is an important issue. Sheriff's office is an important issue. And there seems to be a lot of cross currents where people agree with each other on some things and don't agree with each other on the details. So maybe we haven't reached a consensus, you know, about this office. So I'm going to vote to move this forward, but I'm not committed to voting to be one of the 8 votes to take it to the ballot.
Mr. Chairman?
Okay, very good. Mr. Miller?
There's just too many unanswered questions, too many details floating out there, and there's no urgency. So I strongly agree with the council president that we should just not move on this year and take some more time to work this out. Thank you.
Mr. Jones?
Chairman, I'll be voting no on this as well. When we first started this county government, when it was created, we were looking to increase efficiency. There were too many fiefdoms and too much duplication of administrative services, and we have gained those efficiencies. But now in the midst of those gained efficiencies, there are areas where we need to tease out a greater level of independence, and I think the sheriff's office is certainly one of those areas. And I don't think we've had enough time to actually ferret out just how we strike that appropriate balance. So I'll be voting no on this.
Okay, very good. Any further discussion?
Mr. Chair, even though this is being called my amendment, I will be voting no on it to move it out of committee. I don't think we should pick out a particular office and treat it separately and differently from the rest, and so I'm going to be voting no.
Mr. Schron?
This is a significantly different office in that it has investigatory authority. And so I do see a difference between this and the clerk of courts and those that are administrative positions. This is not what we're talking about here. It's just somebody who's moving the administration of justice. We're talking about the actual investigatory authority that resides in this office. So I do not see this as the same office. I see it as a significantly different office. And to this date, as I think one of my colleagues said, we don't know actually what happened with Sheriff Reed. And wouldn't it be scary if that was an investigatory reason why that person is not there, and this council has not taken the tough step of making sure that that independence resides in this office by making it into a charter. I mean, there's a reason why of the other 87 counties all have a completely independent sheriff that's voted on by the populace. In this particular case, we have one that can be fired at the direction and the whim of the county executive. We built a check and balance in by saying that 6 members of this body must agree, and the communication would take place in executive session. It's not going to take place in a public forum. We're going to hear why that county executive is suggesting this person cannot work with that individual, or that there's reasons of performance, either misfeasance or malfeasance, and then we would come out in a public session, and according to the new amendment that's on the floor, 6 of us, not a very high threshold when you consider the importance of this position. Other 87 counties, it's an elected position.
Any further discussion? Ms. Conwell?
To the chair, I have to agree with Councilman Shrine that this position is unique to other appointments, but I also have to agree with Council President Connolly as well as Mr. Gallagher. This is a big step. And so, everybody has kind of said it, that this really needs, so it's not like, no, we don't agree with each other, that maybe in light of what happened with the previous sheriff, that it shouldn't be investigated or removed or whatever the case may be, but it's just, I think we all agree that this is a big issue to determine, so I will be voting no for it not to move and stay in this committee for further discussion.
Any further discussion? Mr. Germano.
Well, I definitely see we have differences of agreement, and I respect both sides. I can just tell you that in my experience, in 19 years as a council president in Parma, we've had various different police chiefs and different safety directors, and I think this is different. Sheriff, first of all, the executive is, how do you want to say, he's qualifying the person that he wants to work with as a professional, experienced law enforcement person with credentials. Then that person is confirmed by the council. This is not anything light. Everyone knows up here that we take appointments very seriously. So I think the sheriff needs once that sheriff is confirmed, he's been selected by the executive, he's gone through examination by the council. There should be some assurances that if a personality conflict, or any other reason, if he's discharged, I just think it's important for us to give the sheriff some independence, and especially, with, I know there's certain charges under law that only where the sheriff has got control over certain charges. I don't remember exactly what those were, but I support this. I think we are enhancing the charter, and there is a lot of people out there that never thought that the sheriff should be appointed. There's a lot of people I've heard from when we first got into this business that we shouldn't have taken the sheriff from being elected. I think, to the contrary, having the sheriff appointed, we have a professional, not a politician. He's got credentials, he's got a history, and he's being vetted twice. Once by the nominee, second by the council. So I support this wholeheartedly.
Very good, thank you. As one who originally authored the genesis for this, and am supportive of this amendment, which has been adopted and moved forward, we have, this is a different position. This position has investigative authority. We've agreed with the charter that the internal auditor, which is an independent and investigative authority, is set up and is actually under the appointment of council. We agree in theory, as we have with the Inspector General. We'll discuss it later today, but so far to date, we've passed an ordinance to give the Inspector General a little more independence. We've created an agency. There's a provision in here very similar to this as to how we deal with the Inspector General. But when you have a position that has investigative authority, and the individual to which that person reports, who has the authority to remove, is subject to an investigation, either directly or indirectly, and that position is appointed and confirmed by this body, it is my belief that we should go through like manner removal. So I am supportive of this, as is. I would have preferred, as my original amendment stated, a couple stronger provisions. But, you know, sometimes in legislation, you take half the loaf we can get it, and I'm comfortable with what's here. So with no further discussion, clerk, please call the roll.
Mr. Chair, we need a motion
There's not been a
to
motion, okay.
move. It is substituted and amended. Yes.
Motions are made and seconded. Alderman,
The
clerk,
motion
please.
was by Mr. Schron and seconded by Ms. Conwell.
Correct.
And
Roll
this
call,
is to
please.
move it to the full council for second reading on the 22nd,
Correct,
correct?
correct.
Okay, roll call vote. That would be Ms. Conwell? Yes. Mr. Jones?
No.
Mr. Hairston? Yes. Ms. Simon?
No.
Ms. Conley?
No.
Mr. Miller?
No.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
No.
Mr. Schron?
Yes.
And Mr. Greenspan?
Yes.
It's 6-5, and the motion carries.
Very good. The next item on the agenda is Resolution 2014-0166. Will the clerk please read the item?
Resolution number 2014-0166, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 3, Sections 3.05 and 3.06, enacting Article 14, Section 14.01 of the Charter of Cuyahoga County to remove party affiliation from elected county offices and declaring the necessity that this resolution become immediately effective. There are individuals who would like to speak to this item. Mayor Akers. And then Mr. Taft.
And I'll remind my colleagues that this is on page 49 in our package.
And Mr. Chairman, there is a substitute that I have that's been passed out that actually adds in one more component in there, and I didn't know if any of the people would be speaking to the substitute, so if you'd like, I can move the substitute so that it does not exclude anything, it just includes one more provision.
We can hear that out of order. Do we have the amendment, Madam Clerk? Okay. We have the amendment before us, Mr. Schron, if you would introduce the amendment, the proposed substitute.
Yeah, the proposed substitute also goes back and corrects one of the other glaring problems that's in the charter, and that is what I believe is a more, I guess, what I consider to be more voter-centric and more centered focus on the succession for the county executive, and that being to create this same concept that we talked about at the last meeting of bringing in a special election as a concept for replacement versus the 5-member panel that would have been on your nominating committee. So it includes not only a replacement alternative, and when we get to the details, I'll be happy to talk about that, but that's just the thin background. If you'd like me to talk about the entire impact of what it means, I'll be happy to do that now or after it's been admitted or submitted.
Let me ask you, is there anything other than your explanation now that would be necessary to move this item along?
Well, it's just what this does is it says that if the county executive should not be there, that a special election would take place within 100 days of that vacancy, that the position would be filled temporarily by the council president while that special election was being conducted, that then once that election were taking place and the new county executive was in office, that the council president would move back as council president, vacating from that seat. And it says that 100 days should, God forbid, something happen to the council, the county executive, dies in office, leaves for any reason, whatever rationale, there'd be 100 days to replace that person out there. If you look at what takes place, they have an entire country that conducts an election in the country of England within 100 days. Certainly 100 days is enough time to put together a campaign, bring forth the ideas, and elect a county executive in a special election. I just suggested using that exact same language in the county council absentees and vacancies that would take place, so that you can be consistent. But my suggestion to the chair, because I understand the controversial aspects potentially of the nonpartisan, that all three of these would stand as separate votes as opposed to a single vote when you got down to that, because we have not addressed the succession of a county executive other than the county council president, and in deference to our current council president who could move on up, who knows what would be the case in the future, and this would allow for the voters to actually pick the county executive. So that's the background to it.
Mr. Chairman.
Mr. Brady.
You know, I do sympathize a lot with the councilman's perspective about the length of our elections. We've gotten to a place where we now have 2-year elections every 2 years for national and statewide offices, and it's really a lot. I think a little bit too much. And but I want to ask, in terms of this 100 days, would there be a primary and then a general election 100 days later? I mean, you have to have a primary, right? So there'll be 2 elections within 100 days? I mean, is this spelled out specifically enough to?
It was left by ordinance, so we could fill in the details of that. But if you look at what all of us up here on this panel, with the exception of Mr. Hairston, on that very first election, we had an election in September and a general election in November. So within that 100 days, we did have both a primary and a general election in that length of time.
Okay. Well, you know, I think that one of the things that this country over a long period of time has managed to do remarkably is provide for succession. There's almost never been any significant interruption, except maybe a disputed election when succession was an issue. And we've gone seamlessly through amazing situations. And so I don't think succession is really, I think it's an important issue and one to be discussed. And I don't think we've had very much discussion about that. We have some things I know we agree on in terms of the ideas that you've been generating, and I do believe that a special election for you know, the vacancy of the county executive, for instance, would be something that would be desirable, would be a desirable thing. I'm not clear enough on this particular amendment to be able to be supportive of it at this time.
The definition of that was to, if you follow what they did in Cleveland, if you follow the special election procedures in the city of Cleveland, they can get convoluted. They can go on into 2 years plus, which means that you really have almost, for all intents and purposes, you don't really have a special.
And that's just a recent phenomena. Those laws in the city of Cleveland were only changed in the last few years. The special election took place within 90 days of a vacancy forever in the city of Cleveland until just a few years ago when that was changed.
Right, and if we were to pass all 3 of these components, we would be able to go through without having to have any problems whatsoever, and you would have a special election which would follow that old rule, which in 90 days you would have that election. I chose 100 to actually add an extra 10% plus to that length of time.
Well, I think it's interesting. I'd like to hear more discussion about it. Organizing a 90-day election in a city ward might be a little easier than a countywide county executive election.
Well, we
Certainly
sit
would
here
be
with
in-
basic-
Certainly would be interesting.
We sit here with basically 100 days between now and the next county election for county executive, and so I can imagine that the speed of the election is going to pick up in these next basically 100 days.
Okay, great. So I'm going to need some parliamentary assistance here. This resolution has, Mr. Schron is asking for three votes on the, one on the vacancy, one of the executive vacancy of council, and one on the nonpartisan elections, correct?
It is. Just only because this charter did not address the county executive, with the exception of just the county council president moves on up. And I think that when you ask people, does that necessarily follow what the voters would have expected for an executive position to move on up? I think that I believe this helps at least to address, this addresses this, and I know that it was a quandary for the Charter Review Commission. I know they wrestled with it, and this, I believe, would at least pick up a logical way in which we've addressed that. And I think also the nonpartisan aspect, if you check with the League of Women Voters on a national basis for local regional elections, they too support the concept of nonpartisan election for regional local elections.
So my parliamentary question, I look to Mr. Miller, Law Department, is we have a proposed substitute. And in the substitute, it's presented as one resolution. Are we able to vote on individual components of an individual proposed resolution? Or must we vote on the entire resolution and then remove information, remove provisions?
Mr. Chairman?
Mr. Miller.
In principle, it's an established parliamentary motion to move to divide a question, and so in principle you can. I do think that that with these three separate parts, that how those three separate parts probably are going to depend somewhat on how the vote comes out, because they interact with each other. So there may be some of that, and I think that what I would suggest is that that we do vote on the three items separately and find out where we're at, and then if any of them get the required 6 votes, well then we can instruct the sponsor to work with the law director to work out the language that passed, and we get that on to second reading. So we would kind of have to, I think, move to divide the question and move to authorize the sponsor and the law department to work on exact language, and if so, in principle, we could do what's being suggested.
And just as a aside, it's 10 minutes to 4, and I take the chair again at 4:30, so.
Right.
So watch your time.
Right, and we have two more items after this one. I'll ask the sponsor, do you wish to divide?
Yeah, I think that we bring clarity, because I don't think there's any, I know that Mr. Miller said there is connectivity between the succession. I don't believe that there is, other than the voting period of 100 days. I think that can stand on its own. As a matter of fact, I don't mean to speak for the county executive, but I did talk to the county executive, and he is supportive of this language for the 100 days for voting out there. So,
Mr. Chair?
yes.
From the perspective of the law department, the amendment does have to go through as one entire amendment, and then language can be removed as applicable, depending on how the discussion goes. But to substitute the amendment, it would have to go through all as one.
Correct. But we can divide for discussion and bring it back in as one amendment. So to Mr. Schron, is it your intent to request that sections 2.04 and 3.05 be divided from the resolution, but maintain as one voting item?
It was my suggestion that they be divided for discussion and be divided for purposes of voting, because I think that succession of the county executive and nonpartisan can stand as separate items individually out there. So we'll look to the.
These two would remain the same. This one be voted out separate.
That's correct.
Okay, all right. So
I was gonna say, if it helps at all, I'm gonna be voting no on all three, so.
Mr. Chairman, same here.
okay, well, that may pose a different mission altogether.
Mr. Chair, before you proceeded, did you want to hear the public comment? I think that's what we were going to.
Yes, Mr. Tarter.
Thank you very much, Mr. Chair. Madam President, members of council. I want to speak today on behalf of myself individually as the Charter Review Commissioner, as well as reflect on some of the discussion of some of my colleagues. And when we talk about the succession of the county executive, we were trying to determine what the charter says currently, and if we could come up with a way that was more inclusive for how a replacement of a county executive was chosen. Right now, as it stands currently, the council president, who is elected by one of 11 districts, would automatically assume the position of county executive. And we had an issue with that because it was our opinion that if this individual was going to have jurisdiction over the entire county, then he or she should be elected by the entire county. We did not like the idea of having only one section of the electorate determine the county executive in the event of a vacancy by the current county executive. So that was our thinking, if we should have some type of special election within the 100 days that would fill in the vacancy on the county executive. The second item of discussion was pertaining to, let's see, there was the nonpartisan elections, and then there was, kind of losing.
Mr. Tarter, we
Of course, and we're only
set
90 seconds.
guidelines of 90 seconds, so.
Which is fair enough.
I apologize.
If I haven't started a sentence, can I finish a sentence? Well, let me just close my sentence then. Essentially, why we chose to have a special election for county council and a special election for county executive as it stands currently, only the precinct people have input on who the replacement is going to be, which is usually sections of one party. And in the event of a council vacancy, we feel the entire electorate, regardless of party, should have input on who the replacement should be. These are inclusive amendments that were passed unanimously out of our committee, bipartisan, that we feel are deserving of attention and consideration. So
Okay, thank you.
Thank you very much, Mr. Chair.
Madam Clerk, has anyone else?
I just need clarification. I'm
Mr.
sorry.
Akers, Mr. Taft, and Ms. Dietrich?
Hello. As a member of the County Review, the Charter Review Commission, and also as a person who's served in a legislative position in my city, I just want to speak against having the permanent replacement for the executive be the council president. Not all due respect to the current president, but we felt on the commission that the skill sets for an effective legislator are very different often than the skill sets for an executive. And the ability, the amount of knowledge about the day-to-day operation of the county is not necessarily something that the county president is as familiar with. So
All right, thank you. Mr. Taft?
Thank you, Chairman Greenspan, President Connolly, members of council. I rise in support of Councilman Schron's proposal with respect to nonpartisan elections. Democracy works. It works imperfectly a lot of times. Some people say it's the worst system of government except every other, but it works. But it works better when you have greater participation, when you have greater attention to the election. In Cuyahoga County, we are largely, particularly at the council level, single-member districts, pretty much single-party districts one way or the other. They're very decidedly one way or the other. We're electing people in partisan primaries that 20% or less of the people are making the decision. There may be, as there was recently, 5 candidates. Maybe 3-4% of the people can make a decision of who the next councilman's or the next executive or the next prosecutor, as to some extent happened among 5 very qualified candidates in the last prosecutorial election, is going to be. If we take that to the general election and take the top 2 candidates, whomever they may be, you're going to encourage far greater participation of your electorate. I spoke before the Charter Review Commission with respect to an open primary. I've heard certain members of council, I got to listen last time, unfortunately I couldn't come last time, but I heard certain council members speak of having a party designation still possible. And while that was my position at the Charter Review Commission in full deference to your views, I have somewhat turned to the nonpartisan because, particularly with respect to the council races, and it may bring smiles from some of you to know that they are part-time positions by charter, but they may become more part-time for some people in the future. There might be people who are restricted persons under federal law, federal part-time or full-time workers, who might have, like they do in boards of education and city councils.
I'm just trying to control the meeting. If you
sorry.
could wrap up, please.
Might have the opportunity to run, but they would be prohibited from running if it was a partially partisan election, as I understand federal law. So I think the nonpartisan works better. Thank you.
All right, thank you very much. Any other, Mr. Akers, but it looks like, was he the 4th, Madam Clerk? Okay. It's up to you. Very good, thank you. You want to bring forward a motion?
Yes, I bring forward the motion to substitute the legislation that I brought, that I've suggested as a substitute for what was presented first, because this body was asking me to substitute some language other than the 5 members, and it was even suggested, I think, by Mr. Hairston that we use, or somebody, that we use a special election. So I've brought forth that in the language and have substituted that.
Okay, so motion's been made. I'll second the motion.
I don't think it was myself who suggested.
Is somebody, okay, Brett.
Okay, motion's been made by Mr. Schron, seconded by myself.
This gets, for me at least, confusing. Are we voting 3 times or are we voting once?
No, we're voting right now on the original, on the substitute as submitted, as one piece of legislation.
Is this the special election?
This is included in that, yes.
Included.
We're not dividing the issue.
We decided not to divide the issue.
Correct. The reason is it doesn't appear that there's support to move forward and have further discussion on dividing. So we'll have a motion on this resolution now. If it fails, then it fails. If it succeeds, then we'll proceed with dividing.
All that's on the table is the substitute right now.
Mr. Chairman?
Yeah, Mr. Miller.
I'm willing to vote yes so that we can have a proper discussion and get the version that the sponsor wants on the table.
Okay. Very good. This motion's made and seconded. Any further discussion on the motion? Hearing none, clerk, please call the roll on the substitute for Mr. Schron on Resolution 2014-0166.
Ms. Conwell?
No.
Mr. Jones? No. Mr. Hairston?
No.
Ms. Simon?
No.
Ms. Conley?
A resounding no.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes, for purposes of discussion.
Mr. Schron?
Yes.
Mr. Greenspan?
Yes.
Motion carries 6-5.
Okay. So the motion carries. Mr. Schron, if you wish to divide the motion, the substitute. How would you like it divided?
I'd like it divided on the basis of if the law department can see the succession as a separate item, and then the nonpartisan with the replacement as a second item, so that it only need be divided 2 times.
Okay, so as I understand it, look to Mr. King, we're dividing 2.04 and 3.05 as one divided item, and hearing 2.04 and 3.05 as one divided item, and 14.01 as a separate item. Is that correct?
That is correct, Mr. Chair, with the one addendum that the first item would also include the repeal of sections 3.06 and 3.07 as 3.05. The language in 3.05 would supplant it. The first division of the item would include the repeal of sections 3.06 and 3.07. As the language in section 3.05 being added would supplant that procedure.
What it basically says is that the succession will be for county executive based on a special election that would take place within 100 days of the absentee, which means that the current method of replacing the county executive is not somebody who moves permanently from the county council president.
Very good, thank you. And just looking at Mr. Miller, the motion to divide, we need a motion and a second to divide and a vote to divide. Very good. So there's, Mr. Schron, do you wish to make a motion to divide as stated?
I move to divide.
Okay.
Second.
And it's been seconded by Mr. Miller. Any discussion on the motion of dividing? Hearing none. All in favor of divide, we'll do a roll call vote on dividing. Madam Clerk, please call the roll.
Ms. Conwell? Yes. Mr. Jones? No. Mr. Hairston?
No.
Ms. Simon? No. Ms. Conley?
No.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Mr. Greenspan?
Yes.
Motion to divide carries.
Okay, very good. So the motion, the resolution before us has been divided into 2 parts, as was read by the law department. We'll now hear discussion on Division 1, and I assume we vote on these individually as 2 separate motions. So the motion to divide has been accepted. We will now vote on vacancies 2.04 and 3.05 council vacancies with the appropriate language as read by the law director.
Mr. Chair.
Mr. Schron? Did you wish to address these?
I think that everybody, I believe, understands where we're coming from in regards to it, that the vacancies on the council president stepping forward would be replaced with the language that would have the entire populace voting in 100 days of that vacancy opening up. I find it hard to believe that anybody could vote against this, but I guess there are people that don't believe in this concept, but it is that the populace can then find what they believe to be the most skilled person to run a $1.3 billion business of the county, to run the operations of it. I don't, in deference, and I have no, this is not in deference at all to our current county council president, but you could see that somebody doesn't even necessarily want to be in that position. The way the current county charter is, that person moves up to take that slot. And we could have elected the best person possible out of this council to run the council. And that person says, I really, the next day, God forbid, the county executive would not be alive. That person has to move up, has to give up their slot, is no longer on the council, is not subject to being moved back to that council slot, by the way. They give up their slot the way it's currently written, and they have to move forward. So what better way than to let the people decide within 100 days? And by putting this change in, it allows that council president to come back to the council, to be part of this body, to serve the elected position that they were elected for, and to do what we currently have in place means that, God forbid, that we should lose the county executive, whoever that happens to be, and especially even feel more serious about that one, that the person would then move forward into a slot and have given up their elected position. So ask yourself, is that really what you think is in the best interest of our 1.3 million people?
Very good, thank you. Madam President?
As some of you know, I actually lecture on the subject of presidential assassinations and succession to the presidency. But, you know, once again, I keep talking about these unintended consequences. This is just too serious a matter just to vote on this quickly. I think this is something that really has to be thought out. I'm not supporting it because I think that, you know, I'm sure there's a better way than the charter established it. And I think that we need a lot more time to discuss this matter.
Mr. Germano?
Chairman.
Oh, I'm sorry. I saw Mr. Germano first, but
Okay.
if I have a coin.
Okay, thank you, Mr. I'm going to be brief. I like the vacancy of the executive with the interim succession of the president of the council. However, I don't think this county, and I certainly am not ready to go nonpartisan. So I think the council vacancy should still be done by the precinct committeeman. And again, I'm against nonpartisan, but I think it's important, and I don't think we should wait on filling the vacancy. I mean, if we don't do it with this election, you know, when will we ever fill it? We're stuck with this, the current situation. So what I'm saying is 204, I'm for, 305 should stay as it is, and 1401, I'm against.
When he says stay as it is, do you mean with the amendment, Chuck?
No, what I'm saying is,
Or the
council
way
vacancies, if we're gonna have partisan elections, then the vacancies in council would be by the precinct committee people in that, of that county district.
All right, let me go to Mr. Brady, and then Mr. Brady.
Well, I'm trying to follow the ball here. I think that Councilman Strawn has brought up something that you know, has been apparent. Although we just didn't think about it, we went on with our work. We just didn't think about it. Didn't need to think about it. I am for you know, some kind of a special election to replace the vacancy in the county executive's office. But I haven't heard enough discussion about the mechanics of this whole thing to satisfy me enough to vote for this amendment today.
Well, Mr. Chair, if I might say that to vote it out of committee still allows us 2 more weeks, or 2 more meetings to, as we have with a couple of the items, that if the language is not to the specificity that some of the members would like, you still have the opportunity to vote it down. You have 2 more chances, 2 more meetings to vote it down. But to vote it out with 6 votes still allows us to at least continue the discussion in order to address a specific problem that is in the charter on succession. And I am perfectly comfortable with severing this into 3 parts, if that makes it easier for people to vote, because the succession of the county executive is so critical and so important. I really believe it should stand on its own vote, and I would be comfortable if doing a severance that allows us to have a separate standing vote that would work with Mr. Germano on that one also.
Okay. Is there any further discussion?
Mr. Chair?
Yes.
From the perspective of the law department, we would request more time to discuss and work with Mr. Strawn on what the potential legal implications of the special election process would be and how that would interplay with election law in general.
Mr. King, general question. When was this presented to the law department?
The original amendment as submitted by Mr. Strawn was submitted to the law department, I think, a couple months ago. But obviously, last Monday, there was discussion that resulted in further amendment. And I believe I sent it over either Friday or Monday of
Okay, so it's been
last
less
week.
than a week?
Yeah.
Okay. Okay, very good, thank you.
If the body is comfortable doing a division of the 3 votes, I would be comfortable with supporting that. Take 3 votes to separate it, and if one passes, so we would still have plenty of time to vote either up or down in the next 2 meetings. If the language can't be perfected, vote it down at the second or vote it down at the third reading. But at least it keeps it alive because we know that we have a problem here. We know that there's an issue here, and as our council president has pointed out, she is a student of unfortunately assassinations and things like that which have taken place. And this is a very relevant issue. I think that we, as a body, should address. It is not something that we should kick the can down the road on this particular one. This is one in which is paramount, and I'm happy to do whatever the parliamentary procedures are to break it into the 3 supporting votes on that.
And right now, as it's presented, we have a motion which has been made and seconded. We voted on the motion. We voted on the motion to divide into 2 parts. And in order for us to break it into 3, then we would have to rescind the motion, have another vote to break it into 3 parts. If we're going to do that, we've got 2 other items on the agenda, which I'm not sure we're going to get to. So, Madam President, we may need to speak about.
Yeah, because we do have a time issue. We
Right.
have 4:30, we have the regular meeting for the treasurer.
So the last 2 items, we may need to reconvene possibly on the 22nd before our council meeting. We don't have anything currently scheduled. We do? We have a work session? Did not get that on my agenda. All right, then we'll have to work. I know.
Mr. Chairman?
So,
Mr. Chairman?
Mr. Miller.
We could simply recess this meeting. I don't know who has energy left, but we could recess this meeting and do, no, okay.
Getting yellow eyes. My dogs are getting yellow eyes.
Well, and when the clerk and I and the president sat down to go over the calendar, not that we planned for this contingency, but we do have an extra council meeting, the last meeting in August, to get these voted out to the Board of Elections for September. So if we can't do it Tuesday, that's fine. We do have time to hear these other 2 items. The items that have been moved forward can still be presented on the 22nd for second reading. We just won't vote on them as we've done in the past. We voted items out of this committee. We voted them out, and we've held in parts. We've held them in committee, and then we vote them all at one time at one meeting. So it appears we're moving down that path. So we'll try to finish this one up in the next 20 minutes. The next 2 items we will hold till a future dated committee of the whole, being consistent with the mandate of September 5th to the Board of Elections. If that's amenable, I'll look into the president and vice president. Is that amenable? Okay, very good. Then we'll move forward and finish with this item. So, Mr. Schron, you made a motion to divide into 2. Is it your intent to withdraw that motion and then make a secondary motion into 3?
I thought it would be easier to move it to 2, but I will now withdraw that and move it to separate to 3 to be in compliance with what I've heard some folks actually express some interest in.
I'll withdraw my second to divide into 2, and I'll second his motion to divide into 3.
Now you need to tell me exactly the divide again.
The divide will be 2.04 as one item, 3.05 as the second item, and 14.01 as the third item.
And is it still language about the repeal?
Yes. All their language remains consistent.
Mike, does that go with the, which divide does that go with?
That would go with the second division. I
3.05?
might recommend, just for the sake of parliamentary clarity, that if you want to consider these motions, it might be simpler to simply take a vote on the entire item, and if it fails, then make a motion to amend it to remove one or more individual items. I'm just throwing that out there, so.
I think it's easier to vote on the 3.
Thank you for that advice. We'll continue as is. Do we need to vote on the motion to divide into 3?
Yes.
Okay, clerk, please. No, we're dividing from 2 to 3. Madam Clerk, will you please call the roll to divide into 3?
Okay, so we had a first by Mr. Schron with a second by Mr. Greenspan,
Correct.
correct? And this is to divide into sections, and it's 2.04, 3.05 with the repeal of 306 and 307, and then the third division would be 1401.
Correct.
Okay. Ms. Conwell?
Trying to clarify it in my mind. Yes is to divide them into three, correct?
Yes.
Okay, yes.
Mr. Jones?
Oh, yes, divides the three, one, no.
2 to 3.
No. We've taken away the first division, so that was withdrawn. Now it's just we're talking about the question of dividing into 3 instead of 2.
So a no vote will keep it to one piece. No.
Mr. Hairston? Ms. Simon?
No.
Ms. Conley?
No.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher? Mr. Schron?
Yes.
And Mr. Greenspan.
Yes.
Motion carries to
Okay.
divide.
We have three items here. I believe, not only for the sake of brevity, but for the sake of brevity, that we, unless there is something new, some new information to be discussed, I'll entertain a motion and we'll vote on the 3 of these divisions.
I move we vote on the executive succession plan as laid out.
Is that the
2.04.
first division,
The first one.
2.04?
I just want to, give it blur.
Okay, I'll second that motion.
Roll call. This is on the executive.
But the vote will be on section 2.04, the first of the 3 divided segments of the legislation.
We will still have 2 more meetings to get the language if somebody is concerned about the language.
Madam Clerk, please call the roll.
Ms. Conwell? Mr. Jones?
No.
Mr. Hairston? No. Ms. Simon?
No.
Ms. Conley?
No.
Mr. Miller?
Yes.
Mr. Brady?
No.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes, for discussion.
Mr. Schron?
Yes.
And Mr. Greenspan.
Yes.
6-5, the motion carries.
We will now accept a motion for section 3.05, council vacancies.
I move that we adopt the council vacancies as written based on the 100 days special election.
I'll second. Made and seconded. Any discussion? Hearing none, clerk, please call the roll.
Please. Ms. Conwell?
No.
Mr. Jones?
No.
Mr. Hairston?
No.
Ms. Simon? No. Ms. Conley?
No.
Mr. Miller?
Yes.
Mr. Brady?
No.
Mr. Germana?
No.
Mr. Gallagher?
Yes, for discussion.
Mr. Schron?
Yes.
Mr. Greenspan?
Yes.
The motion has failed.
Okay, the third item, divided item, I'll entertain a motion for section 14.01.
I move we adopt the nonpartisan elections in the county of Cuyahoga County.
I'll second. Any discussion on the motion?
Just one comment, that the way the executive has it set up now, if this were to prevail, it's a real possibility that employees of the county would not only be able to run for county government and maintain their employment with the county, they'd also be sitting as elected officials. One of the traps in this that I think is really something that hasn't been thought through.
The only exception to that would be the ORC provision regarding classified employees holding partisanly elected offices. That would still be enforced. That's an ORC provision. But the executive order requiring county employees that work for the executive not to hold partisan or any elected office would need to be repealed, since that's still in effect. Okay, clerk, please call the roll.
Ms. Conwell? No. Mr. Jones?
No.
Mr. Hairston?
No.
Ms. Simon? No. Ms. Conley?
No.
Mr. Miller?
No.
Mr. Brady?
Yes.
Mr. Germana?
No.
Mr. Gallagher?
Yeah.
Mr. Schron?
Yes.
Mr. Greenspan. Motion fails.
Okay, so as we have the legislation now, now it's being brought back together, only one part survived, and that would be the vacancy of the executive section 2.04. So the legislation has so been amended, correct, by vote, and now we're ready to discuss and vote on the substitute as presented, excluding, as presented with 2.04 as the only surviving section.
So you're basically, well, you have to,
That's all that's left.
yeah.
The rest of the resolution's been removed.
You're actually now at this point amending the substitute, right?
We already voted to amend, so it's been amended. So right now, what we're voting on now is the substitute as amended, and the amended only, it is, no, I'm looking for some parliamentary assistance, by us having divided it, then has the substitute then been adopted with 2.04 as the only surviving item?
Mr. Chairman, I believe we divided it into 3 separate sections, and the one section got referred to the council for second reading.
Very good. Okay. Then, as we move forward with this process, the council
Mr.
president.
Chairman?
Yep, Mr. Miller.
Just for you historians out there, I just want to note that I believe that we have had more 6-5 votes today than in the entire 3.5 prior year history of this government.
Well, I would also say I think this meeting was probably, from a parliamentary perspective, the most complicated that we've had. But with that said, we have 2 more items left to discuss, and those items are Resolution 2014-0163 and 0141. The council president and I will adjust the calendar for those 2 items
Yeah,
to be
Mr.
heard.
Chair, I just want to say that, is there a feeling among the committee that we do want, on the council, that we want to deal with this issue of succession, so that there's a possibility of other people may come up with other suggestions as to the succession of the executive? That's the only thing that survived, is that right?
Correct.
Okay, all right.
All right. With that said, council president and I will, yes, Madam Clerk?
I think the law department has an opinion as to what needs to happen next, from what I understand. Well, go ahead.
Right. The vote that was just taken was as to the content of the amendment, but it still needs to be voted on again to send that amendment as
Okay.
voted on to committee.
That was my original belief, but I was so diverted. So the motion then before us is, let me gather my notes.
A motion would need to be made.
Right, we need, right, and the resolution to that is resolution. So I'll entertain a motion for resolution 2014-0166.
So move.
Motion's been made, I'll second the motion. Motion's been made and seconded to send this resolution as substituted and as amended to council for second reading on July 22nd. We've had discussion on it, and now we need to vote the item. Will the clerk please call the roll?
Ms. Conwell?
Yes.
Mr. Jones?
I'm sorry, I need clarification. What are we voting?
They're making us vote again.
In other words, sections 2.04 and 3.05 with the repeal language of 3.06 and 3.07 are coming out of the legislation, and the only remaining piece is 14.01.
I'll
Correct.
still vote no.
Mr. Hairston? No. Ms. Simon?
No.
Ms. Conley? No. Mr. Miller? Yes. Mr. Brady? Yes. Mr. Germana? Yes. That was a yes, Mr. Germana? Yes. Okay, thank you. Mr. Gallagher?
Yes, for purposes of discussion.
Mr. Schron?
Yes.
Mr. Greenspan?
Yes.
Motion carries.
Okay, now, thank you, that motion carries. The last 2 items on the agenda, the council president, vice president, and clerk, we will set a separate committee of the whole to address those 2 items. They will apparently not appear on the July 22nd meeting for second reading. but we have an extra meeting in August to vet that out. Is there any other business before the committee? Any public comment unrelated to the agenda?
Not that I'm aware of.
Okay, we are adjourned.